it has promoted land rights and agrarian reform with the object of redressing past injustices and improving the quality of life and livelihoods of rural people. The applicants all approached the Land Claims Court in July 2013 with their challenge to the department's failure to process land tenant applications. Those proceedings culminated in a judgment and order in December 2016 by Mr. Acting Justice Mogoeng. This ordered the appointment of a special master of labour tenants to assist the court in monitoring the Director General and the department. In the Supreme Court of Appeal, the Director General and the Minister appealed against the appointment of the special master. The majority judgment affirmed much of the Land Claims Court's approach and order, but it excised the heart of the relief that the Land Claims Court had granted, which was the special master. The Supreme Court of Appeal considered this concept of the special master an untimely and alien foreign import. It echoed a warning delivered in this court by our highly esteemed colleague, former colleague Justice Krichler, against the blithe adoption of alien concepts like the special master. The Supreme Court of Appeal thus found that the Land Claims Court had overreached its judicial role. The dissenting judgment in the Supreme Court of Appeal upheld the decision of the Land Claims Court to appoint the special master. The applicants therefore approached this court for leave to appeal against both the special master and the contempt findings. In particular, they sought to restore the appointment of the special master to deal with the bureaucratic backlog and difficulties in the department. I prepared a judgment which is concurred in by my colleagues Mr. Justice Furneman, Justice Kampepe, Justice Madlanga, Justice Mhlantla, Acting Justice Nichols, and Justice Turon. The majority judgment holds that for over 2 decades, the department has manifested what has seemed to be obstinate misapprehension of its statutory duties. It has further shown unresponsiveness, plus a refusal to account to those dependent on its cooperation for the realization of their land claims. The court finds that while the good faith and the good intentions of the department's promises and undertakings may be accepted, repeatedly they have not been translated into effective, rights-affirming, practical action. All this, the majority finds, shows that the mythical spell must be broken and the impasse must be resolved. And this can be done with cooperation, goodwill, humility and respect, and without necessarily adversarial combat between the courts and the department. The courts and government are not at odds about fulfilling the aspirations of the Constitution. And there is no rigid or static conception of strictly demarcated separation of power roles. The different branches of constitutional power all share a commitment to the Constitution's vision of justice, dignity and equality. The 3 branches of government are engaged in a shared enterprise of fulfilling practical constitutional promises to the country's most vulnerable people. It is true that these joint efforts will sometimes generate friction. In cases that cry out for effective relief, however, tagging a function as administrative or executive, in contradistinction to judicial, need not always be decisive. For it is crises in governmental delivery and not the wish on the part of judges to exercise power that demands that the courts explore the limits of separation of powers jurisprudence. When egregious infringements have occurred, the courts have had little choice in their duty to provide effective relief. This was so in the unanimous judgment on behalf of this court by my colleague Justice Furneman. It is also the case here. That judgment was the Black Sash judgment, which is well known publicly. In both these cases, the most vulnerable and the most marginalized have suffered from insufficiency of governmental efficiency and delivery. The vulnerability of those who suffer most from these failures underscores how important it is for the courts to craft effective, just and equitable remedies. In cases of extreme rights infringement, the ultimate boundary lies where the court itself continues to control the remedy. If this requires temporary supervised oversight of administration, where the bureaucracy has shown itself unable to perform, then there is little choice. It has to be done. In this case, the fact that the department's tardiness and inefficiency in making land reform and restitution real has triggered what can rightly be called a constitutional near emergency. This underscores the need for practically effective judicial intervention. Through all times and issues, this court has emphasized the importance of respect for the separated distribution of powers between legislature, executive, and judiciary, and it has enjoined restraint of judicial power. It has displayed it so much that many of its critics have on occasion reproved it for being too cautious. And the courts have never sought to supplant government. They step in only when persuaded that they have to protect rights infringed by insufficient and unreasonable conduct. In Treatment Action Campaign, in which this court ordered a previous government to start making antiretroviral treatment available, this court noted that where the state has failed to give effect to its constitutional duties, the Constitution obliges the court to say so. And in that judgment, my colleagues present here today, Justices Goldstone, Moseneke, and Sachs and Krichler joined. In argument, in this case, the department did not contend that a special master could never be justified. It said there might be circumstances in which it was warranted. This would depend, counsel for it said, on the extent of the rights violations and of the bureaucratic dysfunction in not remedying them. The department contended only that the level of violation and dysfunction here was not extreme enough to justify a special master. This concession was sound. What we have to do is to undertake a careful consideration of where judicial power stops, and with it the practical question as to when court intervention on this scale is justified. It is a mistake to classify the special master as an exotic or outlandish importation. The main warrant for the Land Claims Court's order was our own home-baked statutory powers. Comparative analyses and best practices are helpful in understanding the role of special master, and they mitigate the notion that it is alien. But foreign jurisdictions have affirmed the powers, but the fact that they have affirmed the powers of special masters does not bind us in finding a South Africa-specific remedy here. This is especially so in the nationally imperative question of land reform and restitution. The Supreme Court of Appeal's concern that the special master might be designed to effectively usurp the functions of the Director General and the officials of the department would have been better directed had the Land Claims Court appointed a much more intrusive official. Far from the Land Claims Court abdicating its own powers or usurping those of the department, it set the scope of the special master's mandate itself and retained control over what the special master did at all stages. The Land Claims Court made clear that the special master remains an agent of the court, and that the independence that the special master would enjoy would be a function of its own independence. While it seems that the powers are intrusive, this is only because it is the court itself that is exercising the intrusion in the department. The court is stepping in to ensure that the nationally critical land reform and restitution process makes headway 20 years after it should. In this way, the special master's independence is a constitutionally enshrined project. The Land Claims Court located its power to appoint the special master very much in its own statutory powers, and this court has held that the Land Claims Court enjoys the powers of the High Court in exploring its remedies. As my colleague Justice Mogoeng eloquently reminded us in a case concerning the Electoral Commission, the outer limits of a remedy are bounded only by justice and equity. It may come in various shapes and forms, dictated by the many and varied manifestations of what kind of remedy may be called for. In that case, the court should be wary not to self-censor. It should do justice and afford an equitable remedy to those before it as it is empowered to do. In the view of the majority of this court, the Land Claims Court directed itself properly and scrupulously to the facts before it in appointing the Special Master. These showed failing institutional functionality of an extensive and sustained degree. That cried out for a remedy. In understanding the Land Claims Court's exercise of its discretionary powers, it identified the fundamental issues as institutional and not personal. The fate of the applicant's contempt application against the minister made the same point in a different way, that this was not about personal obduracy, but about impairment in departmental function. A remedy of the kind that the Land Claims Court granted in this case was designed to fix persistent institutional failings that repeatedly resulted in non-compliance with court orders. It was directed to systemic functioning rather than to individual attitudes or failings. This diminishes any personal sting that the appointment of a special master may seem to imply. Instead, it recognizes our joint responsibility as a country for sustaining and growing and strengthening our institution. And it acknowledges our judicial complicity in institutional and systemic dysfunction that continues to impede our attainment of our shared constitutional aspirations and goals. For all these reasons, the majority concludes that the order that the Land Claims Court granted must be restored. On the question whether the minister committed contempt of court, the majority comes to the same conclusion as the Land Claims Court and the Supreme Court of Appeal, that it is not possible on the affidavits before it, in which the minister denied that he was acting in contempt of court, to infer that he acted in bad faith. A second judgment, largely concurring in the first, but differing on the ultimate power of the special master, has been penned by my colleague Justice Jafta, with Acting Justice Ledwaba concurring. The second judgment concurs with the first judgment regarding the Land Claims Court's powers to appoint a special master, but disagrees with regard to the source of that power. The first judgment finds that when appointing the special master, the Land Claims Court was exercising its inherent power under Section 173 of the Constitution. The second judgment concludes that the court was exercising powers conferred by Section 172 of the Constitution. Those oblige a court to make a declaratory order pertaining to law or conduct inconsistent with the Constitution and to make a suitable remedy. The second judgment finds that the power to make a declaratory order includes the power to issue a supervisory order. The second judgment also finds that the Land Claims Court expressly directed the Special Master to prepare and deliver a plan for the performance of the Director General's duties under specified sections of the Act at issue. These included determining the budget necessary to implement that plan. The second judgment found that this went too far. The question that arose for consideration was whether the supervisory jurisdiction, which forms part of the Section 172 power to grant mandatory relief, extends to cover the performance of what are intrinsically departmental functions, including preparing judgments. The second judgment finds that interference by the judiciary on matters that have budgetary implication has always been limited to deciding whether the plan adopted by the executive itself constitutes reasonable measures that the Constitution envisages. Thus, to the extent that the Land Claims Court's order authorized the Special Master to draw up the implementation plan that includes the budget, it went beyond the permissible bounds of judicial intervention. The second judgment would therefore have amended the order of the Land Claims Court to return the exercise of those powers to the Director General and to his staff. In the result, the following order is made. 1. Leave to appeal is granted. 2. The appeal by the applicants in the main application succeeds, and the order of the Supreme Court of Appeal is set aside. In its place, there is substituted, the appeal is dismissed with costs. The respondents are to pay the costs in this court. The order granted by the Supreme Court of Appeal on the contempt application is set aside. In its place, there is substituted, the appeal is dismissed with no order as to costs. The appeal in this court against the dismissal of the contempt application is dismissed with no order as to costs. Chief Justice, I've just seen that we've omitted to give the costs of to counsel, although we say in the judgment itself that it should be to counsel as well. And I'd hereby pronounce that we add those costs. We'll amend the particular printed form of the judgment before it's issued on the internet. I hand down that judgment.